Formation of an agreement is a fundamental concept in contract law. Agreement is defined in section 2 clause E as every promise and every set of promises forming the consideration for each other, and a promise is defined as an accepted proposal. Section 2 clause B says a proposal when accepted becomes a promise. So this is another way of saying that an agreement is an accepted proposal. The process of definitions come down to this. A contract is an agreement is a promise, and a promise is an accepted proposal. Thus, every agreement in its ultimate analysis is the result of a proposal from one side and its acceptance by the other. The kinds of agreement are as follows. First, valid agreement. A valid agreement is the one that is enforceable by law. For an agreement to be valid, it must satisfy all the essential elements of a contract as per section 10 of the Indian Contract Act, which are offer and acceptance, free consent of parties, lawful consideration and lawful object, capacity of the parties to contract, and not expressly declared to be void by the law. Second, void agreements. A void agreement is one that is not enforceable by law from the beginning. This means it has no legal effect. For example, it includes agreements without consideration, agreements made with a minor, agreements where the consideration or object is unlawful, and agreements to do an impossible act.